Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about what helps to win asylum cases. I receive a lot of inquiries from people who already filed their case, but they would like to have an attorney to review the case because they either work with somebody else or they did it by themselves, and they would like to increase their chances of that asylum application being approved. So what really helps from my practice, as I can tell you, what helps to win the case? Well, number one is the use of experts. Primarily, there are two types of experts one can use in an asylum case, to prove asylum case. It's a psychological expert who is going to be a mental health professional who will spend some time with the person, with the applicant, and will be able to evaluate the applicant with regard to any psychological trauma or any psychological state that helps one to prove that they did suffer persecution or that they're really afraid of future persecution. Another type of experts that we would like to use in a case would be a country condition expert. A country condition expert is somebody who is probably a scholar, somebody who did some research in a particular country, and maybe it's a professor from a university of some sort that, or a member of some human rights organization who will testify that the person that he or she got familiar with the experience and account of the events presented by the applicant, and that account of the events is probable. So it seems that the applicant is telling the truth, and the general country conditions are actually confirming what was experienced by the applicant is true. Also, country condition expert can, of course, testify about the future reasonable fear that the applicant might have if he or she is returned to their home country. So it's very, very important. Experts are very important. They're not attorneys as a rule, experts. Under the rule of evidence, you need to qualify an expert to be an expert when you go to court, meaning that all the credentials for the expert should be there, because the government may challenge the person who you designated as an expert is to be an expert. But usually there are no issues with that, because your attorney will advise you if that particular person is suitable to be an expert or not under the rules of evidence. So experts really help. Another type of evidence that I find particularly helpful would be witnesses. Of course, the best witness you can hope for would be a live witness that you can bring to court or to an asylum interview, but it's very, very rare. Almost never happens. So you would have to rely on letters by those witnesses, on affidavits by those witnesses. The key here is to produce that affidavit in the right format that will be acceptable. It either the witness's signature will be notarized, if it's possible, and if it's not notarized, the United States will accept a declaration. It's very simple. You just add special wording on the top of at the bottom of the witness's statement, and it's perfectly acceptable for to use on a federal level in the United States. Because as you can imagine, or as one can imagine, witnesses in a country, if they still reside in a country where a person suffered persecution, they're most likely not going to go to notary. Because in some countries, a notary has to keep a copy of the document that the witness is notarizing. And I can imagine that if the witness will be testifying against the government, they would not want the notary, who very often is a part of the government, to keep a copy of that letter, right? So that's why use of letters and declarations is very, very important, to use a proper use of declarations, because declarations do not require, when you make a declaration, basically the person says, I, so-and-so, declare under the penalties for perjury, under the laws of the United States, states that the following is true and correct, and then the person says whatever they want to say, and in the end they put executed, date, and their signature, and that's sufficient. And that cannot be challenged as not properly notarized. Because if you present just a letter without those words, the prosecutor may say, well, it's not the best possible evidence you can get from this witness. They could have notarized the affidavit, or they could have produced a declaration. And the last thing that really helps, this last thing depends on you, the applicant. Have to be consistent. You have to be consistent in your testimony. And sometimes it's interesting, because sometimes a person says, well, I filed the asylum application at the very beginning and I didn't have a lawyer, but now I would like to produce a more detailed account of the events. And sometimes it hurts the person, because the asylum officer will say, well, you know what, you should have produced that detailed account of the events at the very beginning of your submission, because now I don't know, maybe you're just adding on something that may not be true just to make your application look better. So you really need to be consistent in what you're submitting and what you are saying in court. It doesn't mean that you may not add certain information to the application, okay? It doesn't mean that. But you will have to be prepared for a long explanation as to why the account of the events is changing. It's very, very important to know that. You can read more information about asylum process in the United States and what you need to know about it when you're getting into it on our website, www.shautsova.com. Thank you.